Colleagues, it's the appointed time and we have already formed a quorum. And this is the Bills Committee on Clearing and Settlement Systems Amendment Bill 2015. So it's the election of the chairman for the Bills Committee. Any nominations? Andrew Leung, and any seconder? All right, I accept the nomination. Are there any other nominations? If there isn't, then thank you very much for your support. Do we need to have a deputy chairman? No? Okay. Then we can invite the administration team to join us. All right, let me introduce the government officials with us. Mr. Jackie Liu, Principal Assistant Secretary for Financial Services and the Treasury, and Mr. Esmond Lee, Executive Director, Financial Infrastructure from the HKMA, Mr. Li Shu Pui, also Head of Financial Infrastructure Development from the HKMA, and Ms. Jenny Lee, Assistant Secretary for the Bureau, and Ms. Yvonne Choi, Senior Counsel for the Hong Kong MA, and Mr. Daniel Leung, Senior Manager from the HKMA, and Ms. Mandy Ng, Senior Government Counsel, and Ms. Lonnie Ng, Acting Senior Assistant Law Draftsman from the DFJ. Over to you, Mr. Liu. Thank you, Chairman. This is the first meeting of the Bills Committee, and I'd like to do a PowerPoint presentation to brief members on the Clearing and Settlement Systems Amendment Bill 2015. The whole presentation will be divided into several parts. First, on the background and justifications for the bill to facilitate members' understanding of the bill, and then I'll go on to tell you the proposed regulatory regime and also the main provisions of the bill. And finally, I'll be briefing members on the public consultation that we have conducted and the findings, and also the proposed phased implementation of the bill. First, by way of the background, and I'm sure members are very familiar with that, or you might have used that too. In fact, with advancement in technology, the public is ready to accept brand new payment products and devices. I think it's becoming very popular, and we do have many online and mobile payment services available, and these are mostly available at the retail level, and they are mainly used for products and services. At present, we mainly rely on two pieces of legislation to deal with the related problems. First, we have the banking ordinance, and at present, the banking ordinance only deal with device-based multi-purpose store value cards, for example, AutoPass, which we all have. So there is a value stored in the device, so we call that device-based multi-purpose store value cards. An example is the AutoPass, and under the existing BO, we do issue a license to the AutoPass company. So under the BO is a deposit-taking company accepting the store value. And the other one is the Clearing and Settlement Systems Ordinance, or the CSSO. And at present, the HKMA is empowered to regulate large value real-time payment systems, and such RTG and such systems would be serving the financial institutions and banks, so that when they transfer funds, that would be used for the purpose of clearance, and at present is regulated under the CSSO. But then, as I just said, the two pieces of legislation do not target non-device-based store value facilities, for example, online payment systems, and also retail payment systems, for example, credit card bonus point systems. And therefore, by way of this amendment bill, we hope that for non-device-based payment systems, they would be regulated so that they would be consolidated under the new bill, so that the HKMA will be regulated, so that we can have a consolidated regulation system. So the first part of the system is the SVF licensing regime. That's the stored value facility licensing regime. And the objective of the licensing system is to ensure the safety and soundness of SVF issuers, whether they are in the form of a device, in the form of a card, or non-device based multi-purpose SVF, for example, online accounts, so that for such facilities for the purpose of purchase and payment, well, they will all have to be subject to the regulation by the HKMA. And the objective is to ensure financial security and safety, because for such devices, the coverage is very broad, and the users would also be many, and therefore, if the stored value in the payment facility sustains any loss, then that would also affect the security and soundness of the financial system. That's why, for that purpose, we have to ensure that the protection would be sound, so as to ensure that they are sound and safe. We are also aware that if the amendment bill has got that as the most important objective, then we will also have to be very careful about the scope of the regulation. That's why in the consultation exercise, we also understand the views of the users as well as the business sector. That's why in the bill, there will be exemptions granted to those facilities that would not have a significant impact on the stability of the financial system, and those would be excluded from the regulation of the HKMA. And such exemptions would be applicable to the following. First, the single-purpose SVF. What do we mean by that? For example, cake, cards, and also coffee shop coupons. And they can only be used for the purchase of some bakery products or to buy a cup of coffee. So these are very narrowly defined SVF, and that will not be dealt with under the bill. And second, there are some SVFs which do not accept payment of money of users. For example, some department stores or supermarkets, they also have loyalty or bonus points cards or cash reward schemes. Well, as that would not involve the use of the user's money, and the users would not be depositing money in the account, that's why that would also not be regulated. And third, SVFs which use the same device, for example, they would be using the phone to purchase certain goods and services, and if they are procuring, say, a program or a software or a film, and if they are using the same device to enjoy the services or the products, then this is a single-purpose SVF, and that would also not be subject to the regulation by the bill. And finally, for SVFs with limited usage and float size of not more than 1 million Hong Kong dollars, they would also not be subject to the regulation of the bill. For example, for some petrol cards or some universities or education institutions, if they have photocopy cards for use in the institutions or laundry cards, whereas the use would be very limited and the scope of use would also be very limited, and the impact on the financial system would be very limited, and therefore they would also be excluded from the bill. And the bill would be targeting the multi-purpose payment devices, and we propose that for all the issuers, they will have to be licensed by the HKMA before they can operate such facilities. And we have also made reference to the BO. Well, the AIs are already subject to comprehensive regulation by the HKMA, and therefore they would be treated as having been licensed. And under the bill, the purpose is to ensure that the schemes would be safe and sound in their operations. That's why there are some minimum licensing criteria. We have to ensure that the licensee would be able to meet those criteria. First of all, for those issuers and operators, they have to have physical presence in Hong Kong, they have to be a body corporate under Hong Kong law. So even if part of the systems or services are provided outside of Hong Kong or on the internet, so long as they have a physical presence in Hong Kong, and if they sell such SVF in Hong Kong, they will have to set up a body corporate and an office in Hong Kong in order to facilitate our regulation. Second, for these body corporates set up in Hong Kong or card issuers, the principal business would have to be the issue of or the facilitation of the issue of SVF. They would also have to have sufficient financial resources to support their operation. That's why the paid up share capital should not be less than 25 million Hong Kong dollars. So at this level, it would be set at the same as deposit-taking companies and also the banking institute or AIs under the banking ordinance. And fourthly, the deposit would have to be dealt with properly, so that there would be proper management of float and SVF deposit, so that they would have adequate float safeguarding and they would have adequate measures to safeguard the float. And also for the owners and also the CEOs and also the directors, they have to be fit and proper persons. Their appointment and taking up of the office will also have to be agreed or approved by the HKMA before they can take up important positions in the institution. And these companies would also have to put in place prudential risk management measures, and for fraud and also money laundering activities, they will also have to have a mechanism in place to detect those. So that would be a very important part of the bill. And the second important part of the bill would be the retail payment systems designation scheme or regime. The biggest difference between this and the SCF licensing system is that for credit card, debit card schemes, and also online payment systems and so on, they do not have store value from the users. So the main purpose is to provide settling services or payment for their users, as they do not hold any money of the users. And we have also made reference to other overseas operations. We do not believe that there is a need for us to have a licensing system in place, but then we believe that we can also make use of the existing CSSO regulating the large value payment system, so that we can regulate that under a similar system. So by a designation system, it means that if the HKMA is of the view that the operation of such RPS would have important meaning to the overall financial system in Hong Kong, they can designate such systems, requiring them to be subjected to the regulation of the bill. And as I just explained, the objective is to ensure the safety and soundness of a financial system. That's why they would be looking at several criteria in determining the scale and operation of such RPS, to decide whether or not it will result in one or more of the following circumstances. For example, if there should be any incidents involving such a system, would that pose any monetary or financial threats to the stability of Hong Kong system? And also, whether the public's confidence in payment systems or the financial system of Hong Kong would be adversely affected. And third, if there is any breakdown in the system, would there be any serious or material disadvantages caused to the day-to-day commercial activities in Hong Kong? So whether it's about the amount of money involved, the HKMA will take that into account in deciding whether or not a particular operator would be designated in RPS. And for a particular credit card system, if it's been designated, then it will be subject to the regulation by the bill. And the HKMA can also impose different conditions to ensure the smooth operation of the systems. And such requirements would involve the putting in place of operating rules, and there should also be risk management and control procedures, and measures to ensure their financial stability and so on. So the situation would be very similar to large value clearing and settlement systems, which are already subject to the regulation by the HKMA, and the HKMA will be expanding that so as to ensure that such RPS would also be subject to the monitoring and supervision by the HKMA.
To achieve the two major objectives of the ordinance, we have to enhance Hong Kong MA's supervisory and enforcement powers to ensure that Hong Kong MA can effectively enforce the ordinance. So under the ordinance, we will add ongoing supervision measures. Hong Kong MA will be able to issue instructions, directions, impose operating rules, and make regulations and issue guidelines. And if someone is expected to have breached the ordinance, we also empower the Hong Kong MA to investigate. As regards sanctions, there are two types of sanctions under the ordinance, namely criminal and civil sanctions. Any violation of provisions in the ordinance can lead to prosecution. For instance, an unlicensed SVF issuer is liable to a fine of $1 million and to imprisonment for 5 years. We understand that sometimes not everything should be subject to criminal sanctions. So we have civil sanctions to deal with minor sanctions, such as some reprimand, issue directions, caution, and Hong Kong MA is also empowered to impose a civil fine no more than $10 million or 3 times the extra profits arising from a certain violation. We hope to include all these in the bill. Regarding these supervisory and enforcement powers, well, they are also found in the current BO and also the legislation to combat money laundering. So these powers are found in many financial services related legislation, and we will go into the details when we go to the contents of the bill. And we've also proposed to expand the terms of the abuse tribunal so that they can also deal with related appeals. Now I come to the main provisions of the bill. When we go through the bill clause by clause, we will go into greater details. Currently, the bill is called Clearing and Settlement Systems Amendment Bill 2015. Once the bill is enacted, to better reflect the scope of the bill, we propose to amend the name to Payment Systems and Store Value Facilities Ordinance. Part 2A is a bit longer. It deals with the procedures for issuing licenses, the procedural requirements, obligation of licensees, the reasons for revocation and suspension of SVF license, MA's exercise over management of licensee, requirements on ownership and management of licensee, and also other exemptions are all found in Part 2A of the bill. Another important component of the bill is Part 3A and 3B that deals with MA's investigative powers and also civil sanctions. All these can be found in Part 3B. The bill will have a number of schedules to deal with, for instance, a minimum licensing criteria, licensing fee, grounds for revocation of license, affairs of business of licensee, powers and manager of licensee, SVF exempt from the licensing regulatory regime, savings and transitional provisions. the bill will have related amendments to the following 3 ordinances, including the banking ordinance. As I said right from the beginning, the banking ordinance is already regulating multi-purpose AVF. We propose to transfer the regulation of multi-purpose SVF to this new ordinance. And there will also be consequential amendments. And we also have to take care of anti-money laundering and measures. So we'll make related amendments to, therefore, the Anti-Money Laundering and Counter-Terrorist Financing Financial Institutions Ordinance. Public consultation. In mid-2013, we had a very thorough public consultation of the community and the industry on the new proposed regulatory suggestions, and the feedback was very positive. There was general support because the community felt that an appropriate regulatory regime will add to the public's confidence in this new system. We've also included some comments received during the public consultation, such as scope of exemption, and they've been incorporated into the bill. In April last year, we also briefed the Electoral Panel on Financial Affairs. We also got the support of the panel. Since the bill has everything to do with our financial stability, we'd like it to be passed and come into effect as soon as possible. So it will commence after gazettal of the amendment ordinance, so that the operators may apply for a license, and the Hong Kong MA can also start to regulate and supervise RPS designation regime. As for the sanctions for contravention, we will provide a transitional period of 12 months counting from the date of commencement to allow the Hong Kong MA to deal with all the license applications first, and then 12 months afterwards, so all provisions, including those on sanctions, would come into effect to provide additional or suitable legal protection for all users of SVF. Thank you. Any comments? Mr. Sin Chung Kai? Thank you, Chairman. Thank you for introducing the bill to us. Can you please explain in common terms? There are a few online RPS. What will be the difference before and after the passage of the bill? What extra has to be done, and what extra protection will be given to the community? For instance, Apple Pay, Alipay, and also one that is commonly used internationally. You know what? Many members of the public may already be using these systems. Does it make a difference before and after the enactment of the bill? What is expected of these operators, and what is the additional protection to users? Thank you. There are already online payment system, and they are not subject to any legal regulation. Once the bill is enacted, similar on will first look at whether these RPS are retail payment system or store value facilities. If it is an SVF, first it has to be licensed. So, as mentioned by Mr. Liu, there will be a transitional period of 12 months. We will not stop their operation at once, but they should take that 12-month transitional period to obtain a license for continued operation. But for some RPS, well, they do not have a float. It's just for retail payment settlement. We'll see whether it will impact on our financial stability, the public's confidence in payment systems, and also day-to-day commercial activities. Will they have any material impact on these areas? If the answer is yes, then it will be an RPS designated regime, and they will be subject to regulation. So we'll first understand whether there is any float, whether it is an SVF or an RPS. Use Alipay as an example. Judging from its current mode of operation, it is an SVF, and therefore it has to be licensed to continue its operation. No, your question was not really answered. Mr. Sin Chung Kai would like to hear it in layman terms. Alipay is one, Apple Pay is another. You buy an SVF of $500 in value, and you buy apps and songs. Now we understand. Does this have to be licensed or not? If yes, are they required to be licensed in other parts of the world? Please enlighten us. Thank you, Chairman. Yes, if it has to be licensed, first it has to be physically present in Hong Kong. It must be a body corporate under Hong Kong. Alipay obviously is a multi-purpose SVF for settlement, for payment, and therefore it must have a body corporate working or physically present in Hong Kong before it is required to make a license, and there will be a 12-month grace period for it to apply for a license. For things like iTunes, it is for downloading entertainment programs online. We will study further. It is quite likely to fall into our scope of exemption, because it's quite likely to have a physical presence in Hong Kong. And for other store value multi-purpose SVF, they have to be licensed. So long as they are for multi-purpose and commonly used, then they are required to be licensed in other parts of the world. Mr. Sin Chung Kai, Mr. Liu. I think the greatest difference to the public is more legal protection. With the exception of octopus, there is no real regulation, whereas in fact members of the public have put a lot of money into such facilities, and if they should collapse, users' float may not be recovered, or can only be recovered after protracted procedures. Mr. Sin asked, what protection will there be? With Hong Kong MA being the regulator of this licensing system, we hope that these organizations would operate in a sound and stable manner, and will ensure that users' money will not be used for other purposes, and to minimize the possible loss to users. I think that is the greatest significance of the ordinance to the public. Mr. Sin, is there any time control? It doesn't matter. You ask one more question. My question is very simple. To follow up on the question of protection. If my understanding is correct, even for octopus, it has to got a license from. It has got a banking license. It is regarded as a deposit-taking company. I don't know whether my understanding is correct. There are some protection for users. I think in future, RPS are not required to get a deposit-taking license. is regulation, the same as protection. For regulation, that means Hong Kong MA will inspect it. But should a company collapses, what protection is there to ensure that users' money can be restored? The Octopus company is a deposit-taking company under the banking ordinance. It is an AI authorized institution. But deposit-taking companies are not covered by the protection of deposit regulations. So Octopus is not given any protection, no protection. SVF users float under an SVF in the new ordinance will not be subject to any protection for savings. However, the deposit is important to users themselves.
So in the long-term regulation of this, there are very detailed requirements saying that the float and also the deposit, well, that would also have to be dealt with separate. That would have to be separated from the company's other business, so that that would be stored in a form of guarantee, so that it would not be channeled to other users. And we also hope that the principal business of the company would also be the issuance of cards and so on, so that it would not be doing other forms of business which might channel the funds to those users, so as to minimize the risks for the users. But of course, there is no system that can be risk-free. But then we hope that with the new measures introduced under the mechanism, that would enhance public confidence, and that would also significantly reduce the situation whereby there is no laws regulating that, and the users' loss could be tremendous, because at present there is no law to regulate such activities, and there is also no regulation of the operator whatsoever. Mr. Raymond Chen, I have 3 questions. The first is about the exemptions. Well, for the multi-purpose SVFs, what does that mean? So because that would be distinguished from single-use facility. For example, for coffee coupons, it can be used to buy a cup of coffee or the relevant container to contain the coffee. But then for this particular group, if it's engaged in different businesses, for example, it can be a bookseller, or it can also run cinemas, and they could also work with other store operators. So would they also be subjected to your regulation? So maybe we can ask them to answer the question one by one. Yes, for the single-use facility, basically it's confined to one type of product. And for example, within the same campus, you can have the same company running different products, but then you still use the same card to purchase those products. So the main consideration for single-purpose facility, well, the impact on the financial system would be minimal. That's why we do not propose to include that in the regulatory regime. Of course, in terms of the development of business, very often at the beginning, you may only have a single-purpose SVF, but then when it becomes a multi-purpose SVF, then they will have to be subjected to our regulation. That's why one of the requirements for these companies would be for them to provide information to us. Even though for the time being they are not subjected to any regulation, they will still be required to provide information to us on a regular basis, so that we would be aware of any change in the mode of operation for the company. And if the facility has become a multi-purpose SVF, then they would be subjected to regulation. But then how are you requiring them to provide information to you? Well, at present, thank you, Chairman. Well, at present, we have already, or before the coming into effect of the bill, for some RPS and also for the SVF, we would require them to provide information to us. So would those be figures in the public domain or commercial secrets? For example, for the system, on average, how much money is being stored in the system? Do you know about that? Thank you for the question. We would also ask them to provide the information to us. All right, if you are able to obtain the information? Is it between the two of you? Or is it something that the public are entitled to know? Well, for the time being, we have no intention of disclosing that information to the public. In other words, between you and the institution concerned, is there any rapport? Or else I can just put in a written question asking to get the information about the amount of money stored under individual systems. Thank you for your question. Well, as stated in different pieces of financial legislation, there are secrecy provisions in order to ensure that the financial institutions' commercial secrets would be protected. So if certain information is obtained by the HKMA under the circumstances, that would also be subject to the confidentiality clause. In other words, that's not for the HKMA to disclose to the public. The second question, you said that for some bonus points schemes, they would also be exempted. But then for the biggest bonus point schemes would be mileage programs. Well, I think it's almost like a virtual money, because you can always use that to get air tickets and so on. That would also be exempted. The reason why it's exempted, that's because it's not for the user to use the money to buy a ticket, because he has used the services of a particular airline. That's why he has managed to accumulate the mileage. But then he is not using real money to buy the tickets, so it's not subject to the regulation. But then in some cases, they can also use money to buy certain products, but then most of that would be earned by flying on the airline and so on. But then let's say if he has already accumulated 100,000 points, and if he can pay up another $10,000 or $20,000, he'll be able to buy a particular class of ticket. But then mainly the user would only be accumulating the mileage points after flying on the airline. Well, my recent experience is that recently I purchase something from mainland's Amazon.com, and the way it's done is that well, you would buy one and then you would pay for one, but then on the mainland you will have to open an account, you will have to store some money in the account before you can buy the books. I haven't bought any books yet because well, I tried to download some electronic books, but then I was not able to do it, so I still have to store some value in the account. Alright, for these non-local companies, I don't know if they have a base in Hong Kong or not. But then after the commencement of the bill, alright, if they are making money from Hong Kong people, then you require them to set up a base or to open an office in Hong Kong, and then you will have to tell us how much money you are holding. Alright, if it's over 1 million Hong Kong dollars, for example, if the total value being stored by different users in the community exceed $1 million, then that would fall into the mechanism whereby they would be subjected to your regulation. Is that right? So let's not use the example on the mainland. All right, if it's an overseas company, all right, if they allow users in Hong Kong to make online payments to buy certain products, then how are you going to regulate them? Thank you. For such situations in the future, after the commencement of the bill, they will have to set up a company in Hong Kong, and they will have to get a license before they can provide the SVF service, because basically they are providing this SVF to Hong Kong consumers or customers, and therefore they are really running a business in Hong Kong. That's why they will have to be licensed before they can run such service. As the Principal Assistant Secretary, as the Secretary just said, so that would afford a better protection to the consumers in Hong Kong, because at present there is no law regulating such companies, in particular if it's an overseas operator. So how are you going to regulate them? All right, they will be required to come to Hong Kong to run the business. But then what if they just ignore our requirement? Well, we would then liaise with the overseas regulator. All right, we'll tell them that, all right, your company has not been licensed in Hong Kong, and yet they are issuing such SVF in Hong Kong. And then we will contact the local regulator, and the local regulator will usually take us seriously. What if they just ignore us? then we will put up a newspaper advertisement saying that this company has not been licensed in Hong Kong, and for members of the public, if you use their service, actually they're running this operation in Hong Kong illegally, so you will have to be careful about this. All right, let's not cite the example of a Chinese company. All right, I really don't want to do the business of Raymond Chan, but then he just tries to deposit money in my account because I don't intend to do business with you. All right, you can go to, you can use your credit card to buy products from the other rival or companies and so on. All right, in any event, I don't want to do your business because you want to buy something and therefore you go there to buy something from them. But then I've not put up any advertisements in Hong Kong. I just say that I'm a blah 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 company in Hong Kong. But then you want to buy a particular book from me. That's why you try to set up an account with me. But then if I don't want to do your business, then you can not do anything about me. Indeed, that's true. But then for serious operators, if they really want to enter the Hong Kong retail market, and if they want to have designated store value points for people to use, or if they want to put up advertisements in Hong Kong, or if they want to recruit subscribers in Hong Kong, then under the bill, if you are serious in running such businesses in Hong Kong, and if you are not licensed, then you will be breaking the law. And for the operators who try to put up advertisements in Hong Kong, or who try to attract subscribers to place money in their accounts, then they would be breaking the law. But then even if I put up advertisements, I'm not talking about Hong Kong dollars, I'm talking about RMB. But then in the process of drafting the legislation, we have also consulted those in the trade, and there are indeed operators running SVFs overseas, and they do provide services to Hong Kong users. And once they are aware of our intention of introducing this legislation, they said that they welcome this, because they said that once you have the legislation, I would definitely be getting a license in Hong Kong, because it would be like extending their business in Hong Kong. Because originally they're waiting for people to approach them, but then after the enactment of the legislation, they'll be able to do so in a more systematic manner, and they'll be able to start their business in Hong Kong. And as my colleague Mr. Lee has talked to them on several occasions, so you might be interested in some of the comments that they have given to my colleague. In fact, they do welcome this licensing system. Yes, Mr. Lee. In fact, that is nothing new, because more than 10 years ago, when we started the online banking service for such virtual banks and their services in accepting overseas deposits and so on, the mode of service or operation would be very similar. So how are we going to go about it? So we would look at whether or not they are targeting Hong Kong public in providing the services. How do we determine? For example, do they have websites offering services to Hong Kong people, and what about the currency denomination? Is it in Hong Kong dollar, or whether or not there is a Chinese page? So there are many different factors that we can take into account in determining whether or not they are targeting Hong Kong users. All right, if the legal advice that we obtain suggests that they are targeting Hong Kong public, then number one, we will be writing to them, telling them that you are actually offering this service without a license. So you're offering this SVF to Hong Kong without a license. And if they are an illegal group, then of course they would ignore us. Secondly, as Mr. Lee just said, we would have to look at whether or not they are subject to any local regulation. If there is a local regulator, then we'll be writing to them. Very often we would collaborate with them, and usually we would sign mutual understanding agreement. We would tell them that your institution has broken Hong Kong laws, and we would seek their help in dealing with the case, and then they would suggest that the company should come and get a license from Hong Kong. And if they still insist on ignoring the advice of the HKMA, then the third step for us to take is, as Esmond said, we would be putting up a newspaper advertisement saying that they have broken our laws. And if they refuse to provide the services to the Hong Kong public, and if there is any online company or technology company providing online services to Hong Kong, for example, ISP or telecommunication companies are providing the service to Hong Kong public, then they would also be breaking this law, and it's a criminal offense. So they would refuse to provide a service to that company, and there is no way that they will be able to come to Hong Kong to provide a service. There is a very slim chance that we will have to go that far, because very often when we approach these companies, they are very interested in running a business in Hong Kong. They would like to know more about how they can get a license in Hong Kong, because they are interested in coming to Hong Kong. All right, for the company that I mentioned just now, I have reasonable grounds to believe that they are interested in running a business in Hong Kong, because when I open an account, I already tick in the box that I'm a Hong Konger.
So that company will be very law-abiding, will come to apply a license. Mr. Leung Sing, whether it is Amazon or any other company, I think the purpose, or if a company wants to do business in Hong Kong, he need to be physically present in Hong Kong. But what about his operation? If the settlement processing is done outside of Hong Kong due to cost considerations, and yet all its users are Hong Kong residents, is that allowed under your licensing criteria? Many mainland banks will only allow you to use their cards if there are sufficient deposits. So it's like a debit card. And the holder of the card can be a Hong Kong resident or mainlander, and they can use the debit card in Hong Kong, although the money has been deposited on a mainland banking account. Should there be any dispute in this case, will this ordinance be able to address it? Mr. Lee, first, whether a company would set up a body corporate in Hong Kong with most of its operations overseas. Now, it's just like the regulation of banks. We have operational safety requirements. If the company operates outside Hong Kong without compromising safety and regulatory requirements, then we will allow some work processes to be done outside Hong Kong. But if we think that it is safer for the operations to be kept in Hong Kong, we will require that. This is part of our regulation. The second question, I think it is about prepaid credit cards. Even under the current legislation, such cards are not regarded as SVF. You cannot issue an SVF. You cannot have a prepaid credit card and disguise it as an SVF. So for the case you quoted, it is a prepaid credit card. So the provisions for regulating credit cards will still apply. If it is in fact a prepaid credit card and operates like an SVF, it is not allowed. So I think we're talking about debit cards. Debit cards is not an SVF. You can only spend the amount you keep in my bank. There is no credit at all. So do you regard it as an SVF or not? Hong Kong MA colleagues can supplement. I think it is something like a debit card. If the size of business is quite substantial, while it may not be an SVF, it may fall into Part 2 of our ordinance, that is RPS destination regime under Part 2. if a debit card in Hong Kong has a big, large scale of operation or with many users, and if its operation could make us an impact on the public's confidence in our financial stability, then Hong Kong MA can designate a certain debit card to be under its long-term supervision. While a license is not required, it doesn't mean that we will not supervise the operation of such a card. Yes, there will always be supervision. It only depends on it is under the current legislation on the bill to be enacted. You know, many mainland visitors in Hong Kong have got an SVF. Well, the value may not be too much, but should there be any dispute, now if they are back on the mainland and if they need assistance and they need protection from this ordinance, how are you going to deal with that? I think the number of visitors that are involved may be quite substantial. So how are you going to deal with that? Thank you for your question. We'll first look at who is the card issuer. If the issuer is Hong Kong based, then of course the issuer can offer such a service to local residents and overseas visitors in Hong Kong. The card issuer is subject to our regulation. But if the card issuer is a mainland one, you're not going to deal with that. It should be dealt with by the local regulator of the card issuer. I understand your legislation will only protect card issuers registered or licensed in Hong Kong, but you know the cards will be used all over the world. What about joint ventures? Hong Kong companies may have branch outlets on the mainland. While I do not have any specific information, do you have any? Should there be a dispute, and if the holder or the user is outside Hong Kong and has a conflict with a company which is joint company with a card user in Hong Kong, what would you do that? We do understand that because a few card issuers have alerted us that similar products are already in the pipeline and they also want to apply for licenses. So in Hong Kong, they sell such cards to Hong Kong people, mainlanders, or Europeans. The currency can be in renminbi or Hong Kong dollar. Very often, they will be thinking of renminbi. And it is a joint venture with another credit card company such as Union Pay. Assuming that we have a mainlander who has purchased a card in Hong Kong and he goes to Europe to use it, and yet something has gone wrong. That user, of course, can lodge a complaint with the Hong Kong MA. So there are a few factors at play. The partner of the joint venture may be an RPS designated RPS. So the relevant organization may also be under regulation, and if the user has any problem when it comes to operation, he can come back to complain to us. We have a mechanism to deal with it. Hong Kong MA has investigation powers, and when we carry out on-site inspection, we'll initiate an investigation and impose sanctions where necessary, so the user can come back to complain to us. So at the end of the day, the user or the card holder has to come back and make a complaint in Hong Kong, even though he's overseas. Usually, will require the card issuer to deal with the complaint of his clients first. There should be a complaint mechanism. If he cannot use it in Europe or elsewhere, he should first approach his card issuer to find out what's wrong. And if the complaint is not dealt with successfully, the user can complain to the Hong Kong MA. Mr. Lee, this is already happening. A card issuer, a card issuing bank may have a similar problem. There may be complaints against such cards. I'm just trying to compare what it will be like now and in the future. Yes, there can be a complaint to the card issuer. In future, we have an RPS destination scheme, such as a Master Visa, China Union Pay scheme. They will become designated RPS. So the card issuer may be a certain bank or a certain company. We will also check with the designated RPS. Perhaps there's nothing to do with the card issuer. Perhaps there's something wrong with the operation of the RPS. Maybe there's something wrong with the network for Hong Kong and overseas. So this is another layer of protection for card users. Mr. Chen Chi-chun, I'd like to ask about multinational companies. You said that if the value stored is over $1 million, then it will be subject to regulation. We talk about money stored for its business in Hong Kong, but how do you make a distinction? The company has to first register in Hong Kong. If the business can be done in Hong Kong on the mainland, so will the add value process have to be done in Hong Kong? Or do you have a Hong Kong value store value card, and then the float from this has to be segregated? Well, this 1 million threshold is about single purpose cards, such as cards used in universities. I can't rule the possibility that an overseas card issuer or SVF issuer would only operate in a very limited scale in universities only, for instance, and is subject to our exemption. While I can't rule out this possibility, I believe the chance is very, very slim. A company of some scale would certainly not confine its business to a university or a shopping mall. It is bound to issue a multi-purpose SVF. So this is very common. This is not whether 1 million is too big or too small. It will not just come to Hong Kong for the sake of business from one university or from one shopping mall. So it will fall into the category of multi-purpose SVF and will be subject to the ordinance. So under the new legislation, there will be much more protection for users' float, because users' float will be subject to greater protection. Now, if it is a multinational company, if it has set up a Hong Kong office in Hong Kong, has it got a Hong Kong store value system for money stored into the Hong Kong store value system? It will be segregated from its capital. Is that right? Now, I get your question. Yes, this is very common. Take PayPal as an example. It has got offices all over the world. We've got users all over the world. For Hong Kong users, they have a contract with Hong Kong applicants, not necessarily Hong Kong residents. They can be mainlanders visiting Hong Kong. Anyway, the contract is between people in Hong Kong and also the Hong Kong company. Now, if we are talking about a person having a PayPal account in Singapore, it will not be protected by ordinance. Mr. Sin Chung Kai, I'd like to follow up. So I apologize because I have to come in and go out from time to time. We have to let the public know that even for global RPS, you have to understand who is the party to your transaction. Now, if a person, if he has an account in Hong Kong that is subject to our the protection of our legislation.
So once he's not afforded any protection in Hong Kong, all right. In simple terms, let's say for the PayPal system, all right. If it's on an online system, it's very difficult for you to regulate it. Let's say if I have a PayPal account based in Hong Kong. But then what about PayPal International? Would it be exempted or will it be banned from doing any business in Hong Kong? Would that be the case? Mr. Lee? In fact, we can compare that to banks. For example, if there is an American bank, let's say the headquarters in Hong Kong has a branch. Okay, so there is a subsidiary in Hong Kong. In any event, once it runs a banking business in Hong Kong, it will have to get a banking license in Hong Kong. So they will have to get a Hong Kong branch license and then another one for the subsidiary. So using the example that you just quoted, all right, let's say if it's an international SVF company, when it comes to Hong Kong, number one, it has to set up a company in Hong Kong before it can get a license, and then it can accept Hong Kong customers. But then, if they want to set up a branch in Hong Kong, then under our regulatory regime, they will also have to get a license. In other words, this customer might be using their PayPal service, so one of the customers will be setting up this branch in Hong Kong, and then another customer will be setting up a subsidiary under PayPal, but then both will have to get a license. So it doesn't mean that for the headquarters which has set up this branch in Hong Kong will be able to recruit customers directly in Hong Kong. So it's like multinationals. So it's like multinational banks and multinational insurance companies, I think. The management and regulatory regime is the same. So Hong Kong's regulator will be focusing in their Hong Kong business for the contracts that have been entered into in Hong Kong and also the amount of money received in Hong Kong. So Hong Kong's regulator will have sufficient powers under the law to deal with that. But then, even if it's a Hong Kong customer, but then if we're talking about a New York branch, and if there are transactions which are problematic in New York, then they will have to go back to New York to deal with contracts that have been entered into there. And of course, the regulator would be talking to the relevant regulator, and there are also collaborations between different regulators. But then for the central banks and also the central regulator, we have maintained very close liaison with them, and we believe that in future, for major corporations running such business, many of such business are global in nature. So in terms of our regulation, we would also be explaining to the public as to the scope of our work in Hong Kong. We will also be asking our regulator to collaborate very closely with overseas regulators so that for Hong Kong users, the protection would be most appropriate. Thank you, Chairman. Earlier on, I've also talked to the two Mr. Lees on this issue. So I'd like to follow up on some specific examples. I'm sure in the future, many such service providers will be subject to regulation, and many of them will be coming from the mainland or overseas. And just now we have given some examples. For example, Mr. Raymond Chen said that he tried to buy something from China's Amazon.com, and he felt that the service was targeting Hong Kong people, because if you look at the form that you fill in, all right, they would always list out all the countries and jurisdictions and so on. So how can you say that so long as they have traditional Chinese characters, they are really trying to target Hong Kong people? In fact, English is also the official language in Hong Kong. And you also cited some examples just now. For example, if they put up advertisements recruiting subscribers, and have they used Chinese in their websites and so on. But then just now you said that you would be obtaining legal advice in determining whether or not a particular institution is trying to recruit customers in Hong Kong. But then before we look at the detailed provisions in the bill, are there examples or criteria set out very specifically in the bill, so that if you meet 2 or 3 of those, then you would be caught? So can you give us some more details about that? Well, as far as the provisions are concerned, we have said that if they try to promote or market their services in Hong Kong, then we would deem them to be engaging in such business activities in Hong Kong. So in the law, we try to put it in more embracing terms, because we have used the term promoting, because what we want to do is to afford the best protection to Hong Kong people. That's why if they provide this type of service in Hong Kong, and if they have promoted or marketed their services in Hong Kong, then they would be caught by the bill, and they would be subject to our regulation. But Chairman, if they just said that they are promoting or marketing their services in Hong Kong, then on the face of it, is it precise and concise enough? All right, if we have a company, I don't know, they would not be, they would not take the initiative to approach you. All right, they might not have thought that they have actually promoted it, but then somehow Raymond Chen approached us, and I only accept US dollar or RMB. So they would claim that they have not done so. And of course, if you think that they are problematic, then of course you would approach them after you have made that decision. But then at the same time, for a local consumer, he might not know whether a particular service is licensed or is subjected to Hong Kong regulation, or there is protection or whatever. All right, he will have to browse the website. You may provide a list on your website so that the consumers can find out. But then they will still have to be careful about this. They may have to do some checking. For example, as far as I'm concerned, all right, if I'm using some services in a particular country, if I'm just depositing a limited amount of money, then I can still feel safe. But then it doesn't mean that it's risk-free, because you might say that in the end, you might say that they have yet to join your scheme. All right, they might have yet to join the scheme. Or if you have invited them to join, but then they still have not joined, and as a consumer, I might not know. So how do you manage the public's expectation, and even the company's expectation? The expectation might be different from yours. Well, in this regard, we do have plans. By the time when the bill comes into effect, we have to educate the public. We will be doing some publicity, telling them that there is a new regulatory regime coming into place for the SVF and also RPS, so that by that time, on our website and in the Gazette, we would be listing out those that have been licensed, so that when the bill reaches an advanced stage, we will be doing this. So we'll be doing some public education, because we understand that the public might not be aware of this brand new regulatory regime. They may not know that this card is just for online purchase, because we do understand that because of the coming into effect of this new legislation, the public have to know that there is a new licensing regime regulating some financial institutions if they are providing SVF to Hong Kong public. Yes, PAS, concerning the choice of terms, for example, issue or promoting or resisting the issuance of such facilities. In fact, in the bill, we try to be as detailed and precise as possible. But then we also have to make sure that we'll be able to catch up with advancement in technology. In the end, the HKMA will have to look at the actual mode of operation in determining whether or not a particular institution would be subjected to the regulation of a particular piece of legislation, or whether it needs to get a license. So such determination will be subject to proper checks and balance, and there will be an appeal board to deal with it. However detailed we try to craft our legislation, we will still not be able to cover all the situations in Hong Kong. We have also tried to make reference to overseas legislation in order to be more prescriptive. And I will be giving you more details when we come to the clause-by-clause examination. Yes, Mr. Mok, thank you for your question. There are different levels. As Mr. Liu just said, in the bill, we cannot be excessively detailed, but then we would be issuing guidelines, and the guidelines would be more detailed. So that would be point number one. The guidelines would be explaining what we meant by promoting or issuing and so on. So we will be doing more public education, and the bill would also set out the license number. So if it's an entity, all right, if it's a particular device, you can put it down on the device, or if it's online, you will also have to have it printed. And if it's a company, all right, if a company has been licensed by the HKMA, then in a register you'll be able to find out, and in the device there would also be a license number, so the public will be able to tell whether or not the company has been licensed. All right, sometimes I do buy something online. All right, I would not be checking whether or not they have been licensed by a particular country. All right, there are over 100 countries in the world, and if they are doing business in more than 30 countries, then can you show us examples of web pages showing us whether or not they've been licensed by the UK authority or US authorities and so on? In fact, when these companies are registered in Hong Kong, the paid-up capital will have to be no less than $25 million. So the biggest problem is that the compliance costs would be very high, because they will have to hire people, and they will also have to have people responsible for anti-money laundering activities. So many smaller companies will simply not be able to come to Hong Kong. So the only players that can afford to play that game would be the big players. So is it that you're trying to weed out the smaller companies, and in doing so you're trying to protect the public? Is that right? Well, our bill is open. So long as you can meet the minimum licensing criteria in the bill, then the HKMA has the responsibility to vet your application. As to companies of different sizes or scales, there would be different levels of compliance cost. So the bill cannot possibly cover all the biggest players or the smallest players, telling them what their compliance cost would be. So the only thing that we can do is to put down the minimum criteria, and then in the licensing conditions, the HKMA would be giving guidelines to a particular company as to how they can comply with the legal requirements. So that can be ironed out later. So, for example, the minimum paid-up capital would be 25 million Hong Kong dollars, but that we do not rule the possibility if there is a super large company, if it's running business of a very large scale, then we would appropriately adjust the minimum paid up capital so that there would be a difference in terms of the requirement. So what we just set out was the minimum requirement. You have further questions? So would you allow me to continue? I'll try to finish with the related questions, because just now, Chairman, you just asked another question which is different from what I was asking. All right, to follow up on what I asked earlier, is there a chance that this will happen? For example, if there is a company, let's say my branch in China or Thailand is doing this business. All right, they have a parent company which has set up another branch in Hong Kong, but then they said that this had nothing to do with them. Do you understand what I meant?
They have this service in their branches in Malaysia and Thailand, and take the case of Mr. Chen Ji-chun. He has deposited money with that, and in Hong Kong there is only another branch office of the parent company. Is there any chance that the parent company would clear itself of its responsibility? Do you have the power to say that a certain parent company is relevant or not? The company has to be a body corporate under Hong Kong law, and the RPS or the accounts will be subject to the regulation of Hong Kong MA. Overseas branches by the same company outside Hong Kong, where if the accounts were opened with these branches, of course they would not be subject to our regulation. So for Mr. Chen's case, it depends very much on whether the money was deposited in an account of the SVF licensed in Hong Kong or an overseas account. If it is the latter, then it is not subject to our regulation. It's just like a resident of Hong Kong with a bank account in the UK or has taken out insurance in Switzerland, then the case will have to be dealt with by the respective regulators. But there can be a confusion, assuming that the company name is ABC, and ABC Hong Kong is under your regulation, but inadvertently I opened an account of ABC Malaysia, and you may say that because the main clients are not for Hong Kong, and therefore the user will not be protected. Yes. Let me supplement once again. If it is a body corporate incorporated in Hong Kong, then it will be regulated by Hong Kong MA, and Hong Kong MA has the power to require the company to ensure that confusion or the possibility of misleading the public in its representations can be minimized. Compared with the current situation where there is no control whatsoever, the ordinance is a big progress. At least we can regulate its business in Hong Kong. We can ensure that its representations in Hong Kong can avoid the possible misunderstanding referred to by Mr. Mok. Yes, you have to do more in publicity and education. I just want to say that this is likely to happen. Yes, it may be better than what it is now, but my worry is the public, once there is legislation, think that ABC Hong Kong is just the same as APC Malaysia. It's true that ABC Malaysia doesn't serve mainly the public of Hong Kong, but still, if a user is caught, what protection can he get? I don't know whether you have assessed this possibility. It's true that it is better than having no protection at all. What my worry is, people may think that once they've worn the seatbelt, they would be safe in any collision, when it is not really the case. Mr. Lee, the law will require the company operating the SVF to include its license number in its card if it is a body corporate, and if it is online, then the license number should also be displayed at a conspicuous place. So members of the public will have to ensure that there is a license number in order to be protected. If the company is from another jurisdictions, then very likely the user will not be protected. Page 4 of the presentation talks about criminal sanctions. Now, ABC Hong Kong is licensed here, but ABC Global is not licensed here. So ABC Hong Kong is set up to do business in Hong Kong. But, the internet knows no boundary. So I'd like to know whether there are any prohibited acts by ABC in Hong Kong. ABC in Hong Kong is licensed to solicit business, but what about ABC, its parent company? Well, even there may not be any ABC Hong Kong. There is a certain company, the internet knows no boundary. There is an IP address in Hong Kong who logs in and apply for the SVF. What will happen? Or do we have any jurisdiction over that? Well, we have discussed this. If ABC Hong Kong is licensed in Hong Kong and ABC Global and overseas company operates unlicensed in Hong Kong, then as I said, we are going to liaise with the local regulator to stop it from so doing, because it is operating illegally in Hong Kong. We're going to penalize it. A licensed operation in Hong Kong is liable to a fine of $1 million and imprisonment. So we have a series of measures to tackle that. Although what Mr. Sin said is likely to happen, we can still address that in our licensing conditions to minimize the possibility of this from happening. For instance, when we issue a license to ABC Hong Kong, we can require ABC Hong Kong to conduct all its business in Hong Kong using this company. This will be one of our licensing conditions. If we issue a license to ABC Hong Kong and yet what Mr. Sin referred to happens, this is undesirable. So we will try to minimize any possibility of ambiguities. All right. Now I will rephrase my question. Take G20, G7 as an example. Many financial regulations are implemented because of international conventions. I'd like to know for this whether there is any basis. You said that you are going to inform the local regulator to take action, but the local regulator there may not address or may not regulate such activities. So I'd like to know whether there is any global consensus on the regulation of RPS. According to my understanding, G20 does not have any unified regulation of RPS or SVF. But when we did the policy study, we reviewed different practices in the UK, Singapore, Malaysia, for instance. These jurisdictions have enhanced legal backing in recent years to set up a similar licensing system. So we believe that gradually there is the sentiment to regulate such activities, although there is no international organization to say that this is the standard way of regulating this and you should all follow. We have considered jurisdictions with a similar mode of regulation, and we have also reviewed the experience and effectiveness. So you said that Singapore and Malaysia and the UK have started to do this. Can you give us a table so that when we scrutinize the bill clause by clause, we will know what other jurisdictions are doing? This can certainly be done, Chairman. Yes, we can prepare some information for members' reference. Mr. Lee? For companies that are interested to do business in Hong Kong, over half of them are from the mainland. Mr. Lee has more than half a year ago led a delegation to the People's Bank, and they're very interested in regulating such activities, and we are now regulating a framework of Memorandum of Understanding. Now, if we want to do on-site inspection, we have to cooperate with the People's Bank of China. They are very supportive of our proposal in terms of division of labor and sharing of information. They are willing to sign an MOU with us. And for Singapore and the UK, we have told them that we have a new piece of legislation in the pipeline. And as a next step, we're going to discuss with other jurisdictions on cooperation. Yes, we can prepare information papers for members to share with you overseas experience. I'm sure this will be of use to members. You told us that half of those who have indicated the interest to come to Hong Kong are mainland-based. I'd like to know whether they are being regulated by the mainland mechanism. Although you're going to give us supplementary information, I'd like to hear now. They are subject to a third-party payment law. So there is a relevant law on the mainland. So if we come to an MOU or cooperative oversight with them, there shouldn't be any problem at all. And returning to Mr. Sin's question, on G7 and G20, yes, we do not have any multilateral consensus yet. But when it comes to bilateral agreement, there are already some. We have bilateral understanding with some jurisdictions. What other jurisdictions apart from the mainland? The UK, Singapore, the US, Malaysia, and Australia. All these jurisdictions have similar legislation in place. Please give us supplementary information. There is no hurry in passing this legislation because this is relatively new. I think we should sort things out very clearly first before we start clause by clause. And let's wait for further information from the administration. I still have further questions. Okay, Mr. Mok. I'd like to know more. You said that a local company or overseas company may not apply for a license as required, and are you going to sanction that company using the IP provider? Can you be more specific? Are you asking that IP provider or that the internet provider to stop services for that company or to punish it? This may not be effective now, because if it is an overseas company, it's quite likely that it is using services from internet service providers. But since you mentioned it, I'd like to know whether there is any liability on local ISPs. Mr. Lee, well, there is something in our bill. If an ISP provides services for these unlicensed companies to promote its business in Hong Kong, we will not enforce the law at once. We will first approach the ISP telling it that a company using your service is against Hong Kong legislation, and we will ask it to stop the service. And if the company continues, then we have criminal provisions to tackle them.
Well, first, you might also understand that there are other pieces of legislation. For example, recently we've been talking about the copyright ordinance, and they will also have this provision saying that for internet companies, if they provide assistance in accordance with certain code of practice, then they would enjoy some safe harbor or exemption under the law. So would you be extending such exemptions to those companies providing such assistance? And in some cases, some internet companies would be concerned about enforcement. So what is the code for enforcement, and what are your requirements on them? Would that be very clear? Because in the past, where enforcement action was taken, the police or other departments, in order to collect more evidence, well, before they can take out prosecution, if they just needed to collect some evidence, then they would just rush to their office, or they would just give them a call saying that they would have to seize the computer. But then they would say that if the computer is seized, then that would have a very serious impact on their operation. So we have also seen such examples when the police or other enforcement agencies enforced the law, that would bring some inconvenience to those companies. So you might just have the liability provisions in the bill, but then if that's the case, then many internet companies or telecommunications companies would be very concerned. Well, even if it's not arbitrary, the impact on them would be very serious. So on your part, would you consider some concepts of safe harbor, so that if they are willing to do something, then that would also help you solve your problem? So that's the same for the copyright ordinance, because the whole purpose is to resolve the problem more expeditiously, so that the matter would not be dragged on. So if that should happen, in fact, such circumstances would be rather obvious. So would you be prepared to consider it? All right, I'll give an overall response. Well, as far as the law is concerned, for the websites and the internet companies, we would require them not to provide the service to the unlicensed companies. And of course, in the law, there are penalty clauses. And if anybody can come up with a reasonable defense, then of course he will be acquitted. So he can come up with a defense and he'll be found not guilty. And we can also look into the suggestions made by Mr. Mock as to other possibilities. Where necessary, we can also see if we can better deal with that under the guidelines. All right, there is still some time to go before we move on to the clause-by-clause examination. We'll give you more details when we come to the clause-by-clause examination. I'd just like to raise one point, and the DFJ might help them in the preparation. All right, is there any legislation saying that for an internet company, which is a host, and if they are responsible for doing some unlawful activities like bookmaking activities. So would you be investigating into them, and what will happen? All right, we will look into it and we will come back and give you a response. Raymond Chen? Well, I hope that you can also see if you can have that information. All right, many such companies would be from the mainland, and the payment system or the SVF, all right, there is no law in Hong Kong right now to regulate such activities. But then for these mainland companies, they might already have worked with overseas, and they've already established a relationship with other jurisdictions with such laws in place. So how many are there? Well, we'll take a look. For some of these companies are overseas companies. We can conduct some studies to find out the situation. So what's the market situation like? Okay, so we will provide the information in one go. For example, our internet logistics companies, the largest one, might have made a lot of purchases in the US, but then because of the constraint, the information that we can get hold of might be what you can also get hold of from the market. So we'll see what we can do. Well, for this stage, I don't have any legal issues, and then for the drafting issues, I'll raise them as we move along. I think we have to invite the deputations to come, so we will have to fix a time for the meeting with the deputations. So we'll invite the deputations to come and give us their views, and then we'll wait for the administration to respond to the issues raised at this meeting. All right? Can we continue to ask questions? Yes, ask if you like. So I'm easy. Chairman, I'd like to make a suggestion. I don't have any questions. Well, when we invite deputations to come, I think we need to invite them, and we have to make an open invitation. But then at the same time, we should also be inviting those who are running a business in Hong Kong already. And for the international practice, we need to find out more. And also for the MOUs that you have already entered into, I'd like to know a bit more. Well, have you signed those MOUs? And what is the content of those MOUs? So can you provide the information to us? And given the fact that other jurisdictions have already put in place regulatory regimes, and if you have the information with you, then can you also make a comparison as to the areas where the bill is proposing to regulate? So what are our commonalities and what are our differences from their practice? So can we have a comparison of the different jurisdictions doing this? So we should not just have one-on-one comparison. We should be comparing ourselves with different jurisdictions. And you said that on the mainland they've already got a law regulating such companies. But what about the non-compliances? Do you have the information? Well, we'll see if we have that information. So we will provide that if we have. Charles Mock. So I'll just raise a couple of points to see if you can supplement that later. Just now, you said that you might have contacted some companies and you might have a list. So is it okay for you to disclose that list to us? So they are interested in coming to Hong Kong. So we'll take a look, because we have no problems about that. But then if they don't want to disclose that so soon, well, this might have to do with their commercial secrets. So if they do not object, then we will provide you with the list, because we'd like to know if you have done any assessment. All right, after the license is issued, then some companies, so there would be this additional threshold for them to meet. So for the companies that you have contacted, some of them might be local companies, others overseas. So have you done any assessment whether or not there would be an impact on them, or is it that there would be no impact whatsoever? Is it that some companies might think that, well, this threshold might be too high, and given the small scale of their operation, they would be excluded? Well, given the companies that we have approached, none of them feel that the threshold is too high. In fact, they express welcome. They said that if the law is enacted, then they would come to Hong Kong. So most of the companies that we have contacted have given us this almost unanimous response. All right, for a company having this settlement system, they would think that the higher the threshold, the better. Well, another point raised by the member was about the list of the relevant parties. In fact, in the consultation report published by the government, in the annex for companies or the respondents who allow us to disclose their names, they have been set out in the report already. So you can contact the Secretariat. All right, in the annex you can compile the list from that. So you can also consider inviting them to come in your public hearing. Well, some companies might already have been subjected to similar regulation in overseas jurisdictions. Can you also give us a table? Yes, we can see what information we have, and we can provide it in the paper next time. And if we were to organize a public hearing next time, you can also invite them to share that experience with you. For the dozen or so companies which have already been subjected to similar regulation overseas, all right, we'll see if we can find a public register for that. And you can also give us the list, and if members find it necessary, they can also look at the list. All right, if there are no further questions, then we will wrap up our meeting here. And then once you're ready, please contact our secretary. I believe that so we'll see if we can fix a date after the 13th of March. So we'll look at the room arrangements, and we also need some time to prepare for that. We are actually thinking about a date in the second half of March, say after the 20th. All right, meeting is adjourned.